Okay, today is April 11, 2012. We're going to pick up where we left off last week. We began learning Module 6, and I'll try to make some headway into learning Module 7, which was a one-week module on confidentiality. When we left last week, we began talking about hearsay. And I gave you some of the basics of hearsay, that it is an out-of-court statement offered in the courtroom for what purpose? What's the purpose of offering that statement in the court? What do we want the jury or judge to do? Well, allow it, but what do we want them to do? It's the third part of my simplified definition of hearsay. An out-of-court statement offered in the courtroom to do what? To prove the truth of what the words say. And you might say, well, what's that supposed to mean? Isn't that why people use words? I mean, it may not be clear to you. It may not be clear to you why that last part, to prove the truth of the matter, is so important and why it's relevant. Well, let me give you that example again. Imagine Danielle is a 15-year-old girl at Eastside High School in Patterson. She walks up to Officer Bill Mott. She says, I don't want to go home. My Uncle Manny, my mother's brother, he touched me on my vagina without my permission. And I want it to stop. Now, if Officer Bill Mott, who's the school resource officer, he's the policeman who's assigned to the school, if that cop comes into the courtroom and offers Danielle's statement to the jury, it would be an out-of-court statement because Danielle made it at Eastside High, right? The cop is in court, so it's being offered in court. And this part at the end about for the truth of the matter, we're offering it in court for the truth of the statement. That simply means that Bill Mott is testifying about what Daniela said because the prosecutor or the deputy attorney general, the lawyer, wants the jury to believe that Danielle, in fact, was touched on her vagina by her Uncle Manny. It's offered in court for the truth of it. We want the people who hear the statement to believe that this girl really was touched on her vagina. And again, you might say, what else would the purpose of it be? Why else would somebody come into a courtroom and testify about something if we don't want the people to believe the words? Well, sometimes court hearings, sometimes forensic proceedings, legal proceedings, are about different things. Suppose, if you will, that Danielle had applied for a restraining order. Okay? And suppose that the test, and this isn't the test, but suppose that the test of whether Danielle gets a restraining order against her Uncle Manny is whether she's afraid of him. If the test for whether she gets a restraining order, if the only question that the judge has to answer is Daniela afraid of her Uncle Manny? Right? If that's the equation that has to be solved by the judge, then whether it's hearsay or not might be different. And I'll tell you what I mean. The judge wants to know if this kid is genuinely afraid. It doesn't matter if he's truthful or not. The only issue is whether Danielle is truly afraid. Well, if Officer Mott comes into court and he says, I spoke to Daniela in the hallway at Eastside High, and she said to me, my Uncle Manny comes in my bedroom at night and he touches me on my vagina, and he does it without my permission, and I want it to stop. I don't like when he does that. I'm scared of him. Well, then if Officer Mott tells us about Uncle Manny coming in her room and touching on her vagina, the purpose wouldn't be to prove that she was being touched on her vagina. The purpose would be to show that the kid's afraid of Uncle Manny. So that wouldn't be hearsay. Now, it gets a little complex here, and I don't expect you to remember it or understand it completely, but I want you to kind of appreciate that third prong. Out-of-state out-of-court statement offered in court to prove the truth. Well, if the kid is shaking when she's talking to Officer Mott and she says, my Uncle Manny comes in my room and touches me on my vagina and I want it to stop, and he doesn't have my permission. Well, if the purpose of that statement is to show the kid's afraid of Uncle Manny, then Bill Mott isn't offering that. The cop who's on the stand and the prosecutor who's working with him isn't offering it to prove that she was touched on her vagina. She may not have been touched on her vagina. She may have been mistaken. He might have touched her on her thigh, or he might have been shooing away a fly, or he might have been helping her adjust her pants, or he might have just been reaching for a toy that belongs to his daughter that was near her chair. That's not the point. The point is she afraid of Uncle Manny? So let's deconstruct the statement again by Danielle. Did she make an out-of-court statement to Officer Bill Mott at Eastside High School?
Yes.
Yes. Is that statement being offered in court? Yes. Are we offering that statement to prove that she got touched on her vagina? No. We're offering it to show she's afraid of Uncle Manny. Thus, it wouldn't be hearsay. Because hearsay requires that third element to be demonstrated. The truth of the matter. The truth of the matter. Okay? That may come up a little bit in a moment when I talk to you about a couple of other hearsay exceptions that are in Professor Meyer's book. In any event, that's where we left off with hearsay. We talked about some examples, and the number one example that we talked about was the tender years exception. The one that is supremely relevant in child maltreatment cases. And I put it up on the big board again. I'll give you an example. True or false? True or false? Gabriella, that's Danielle's sister. Gabriella watches Uncle Manny go in the room and put his hand down Daniella's pants and rub her vagina while Daniela is frozen with fear. Gabriella sees the whole thing. Gabriella is shaking, but she plays possum. She lays in bed and doesn't say a word. The next day she tells her brother, who tells her mother, and word gets out that Manny molested Danielle, and that Gabriella, the little sister, age 8, saw it with her eyes. She is interviewed by the police on video by a forensic interviewer. Gabriella describes what happened to Daniela. The Deputy Attorney General wants to offer what Gabriella saw through the forensic interviewer, who put it on video. So they offered the video of Gabriella's interview. Is the video hearsay? First question.
Yes.
If Gabriella was interviewed by a police officer or a forensic interviewer at the prosecutor's office or at the police station, where was Gabriella's statement about what she saw made? Was it made in court or out of court? Out of court. So it's an out-of-court statement. Don't be misled by video. Just because it's documented, you can see it, it's compelling, and everyone can watch it, doesn't make it any better or any more reliable. Primarily because you can't cross-examine the video. You can't ask you questions. It's just a bunch of ones and zeros if it's on a computer, and it's just a piece of plastic if it's a DVD, and it's just a bunch of celluloid if it's a VCR tape, VHS. It's just something that doesn't answer questions. So video recordings of statements are made out of court. They're offered in court, and usually offered in court so the people who watch them go, oh my God, this is what happened. It's offered for the truth of what's on the video. Well, in this case, we want the world to believe that Gabriella watched her sister get molested. So it's an out-of-court statement offered in court to prove the truth of the molestation. But the Deputy Attorney General says, aha! Gabriella's only 8. I'm going to offer it under the tender years exception. She's 8 years old. Is she under 12? Yeah, so that applies. So it would be true that the DAG can get that statement in by Gabriella. True or false? Perhaps. It's not even perhaps. False. False. Can someone tell me why it's false? I'm going to sit here and you're going to read that and you're going to tell me why it's false. I'll give you the facts one more time in case they flew over your head. I'll let you answer it. I think you know. Daniela's being molested in her room. Gabriella observes it. She watches it. She gives a video recording. She's only 8 years old. She's under 12. She describes in great detail what happened to her sister. She tells about this sex act. And the prosecutor or DAG offers it in court to prove that Gabriella saw her sister being molested and that Manny is guilty. Go ahead.
I thought it's because it's not against herself. She's saying she saw it with someone else.
Excellent. The answer is, one of the elements is that what you were going to say? Good. One of the elements is that the sex act, because we have that. Let's go through the elements now. Kid under 12, got it. Sex act, got it. Right? Upon the child who's in court testifying. Don't have it, right? The sex act was on Daniela. It wasn't on Gabriella. She was a witness. Right? So that would fail. Now, let's say after he molested Daniela, he goes over to Gabriella's bed and he fondles her. Gabriella not only describes what she witnessed about her sister, but she also describes how Uncle Manny fondled her. Then it would come in. Under 12, sex act upon Gabriella. Now, that's not the end of the issue. What does the court have to do? What do they have to do to make sure that it comes in and that it is good hearsay? She has to say it in court, and what's the court's job? To determine what before it gets in? Whether it's what? It's up there. Take a moment to read it. Admissible, but what's the standard? What are they going to look for? What's the... They got to determine whether it's trustworthy. They got to determine whether it's trustworthy. Understand? So, kid under 12, sex act upon that kid, and then you got all those, then the court says, okay, tell me the story. I want to hear what Gabriella said and how she said it. And then I'm going to determine whether it's trustworthy. Because remember, hearsay is generally inadmissible or not allowed in court because it's considered unreliable. We talked about the game of telephone. We talked about the fact that you can't cross-examine Bill Mott about what Daniela said because Daniela is the best witness about what happened to her. Bill Mott doesn't know whether it was light or dark, how far away Daniela was when he walked in the room, what it felt like on her body. You know, those issues are not something Officer Mott knows about. So the defense lawyer can't cross-examine Daniela, so that makes it problematic. That's one of the main reasons why we don't like hearsay, because it violates the Sixth Amendment of the Constitution, which requires that we're allowed to cross-examine or challenge witnesses against us. And the other thing is it's just not reliable. It's a statement made out of court. It's not from the best witness possible. It's filtered through the mind and perceptions of some other human being. Thus, it degrades. It's not reliable. And people have different motives to say things. That person may have had a motive to fabricate. Daniela may be jealous that Uncle Manny's allowed to live in the house and doesn't want him in the house. So maybe she said that just to get Uncle Manny kicked out of the house. So she could have thought about it, reflected, and made it up. And we'll never know, well, we won't, it'll be harder to know because she won't be the person who testifies. We'll just put a video on if we let it in. Now, some hearsay statements, some out-of-court statements are more reliable than others. We start out with no hearsay. Maybe some hearsay. Okay, what does that hearsay look like that we break the rule for, that we make exceptions? Almost always, the hearsay is a statement that has super reliability based upon the way it's said or the context in which it's said. Give me an example I left you with last week. Remind me, because I got a lot of pain in my knee. I went to the doggy park with Harley, and I was playing football with two little boys I brought. I took my son on a play date. And I ran a flea flicker. See, I went back, I flipped the ball to little Joe Dixon. I said, you throw me the ball. But there were all puppies there and dogs of a variety of sizes, mostly the small dogs, because I was in the small dog park. and a large belly dachshund, a big fat belly dachshund, the perfect dog to fall over, got under my feet, and I exploded off the line. I was like, catch that fast. But I didn't see the little dachshund. And any other dog, either I would have crushed or I would have bounced into, but the dachshund is just the perfect height and weight for your foot to get right under him. I went, whoa, boom, and my knee hit the ground. And I was in tremendous pain. This hand's still a little swollen, much to the delight of the people who go to the park and perhaps are upset by my obnoxious football playing in the dog park with the boys. So I had to go to the doctor. I was thinking about going to the doctor, and if in fact I went to the doctor, what does that have to do with hearsay? When I go to the doctor and he wants to know what happened, he takes a history, she takes a history. What does it have to do with hearsay?
Statements given to a doctor are reliable.
The assumption is I'm not going to lie to the doctor. I'm going to tell him the truth about what happened because I want my knee to stop pounding. And then I had a knot the size of a golf ball on my knee. I was thinking about maybe going and get it checked out, but the swelling went down eventually. The point is, certain statements have super reliability. One of the ones that we talked about was statements to doctors for the purpose of diagnosis or treatment. Diagnosis or treatment. And I'll show you how critical it is that all the elements are met when I describe to you a case that I had some years ago. I had a case involving a defendant named John Thomas. Now, John Thomas was in his third relationship. He may have even been married to the woman who was central in this prosecution. I don't remember. But I know that his first family, he molested the girls in the family. And that was, whatever happened there. And then he took up with another woman and he molested her kid. Now, I had the third woman that he took up with, and he molested her daughter. Excuse me. And we were prosecuting John Thomas. But the girl, who was about 14 and a half, maybe 15 at the time, would not testify. You see, her family were Jehovah's Witnesses. And they didn't like what happened. They wanted him to get help. And they wanted to make sure that they were safe and that the children were safe, but they will not judge another. And I said, well, I respect that, but we're going to trial. Because this man is going to jail. He's going to be held accountable. Nevertheless, the young lady and her mother and family were firm in their belief and their position that they would not testify. So I had a dilemma. Now I thought about it and I said, how can I get what she said in the past in front of the jury in this case? Because if she doesn't want to testify, I'm going to need what she said outside the courtroom introduced in court. I'm going to need hearsay in. Well, would the 10 years exception apply to a 14-and-a-half-year-old, almost 15-year-old girl? No. She's over 15, over 12.
I was just wondering, if someone is 12 when it happened, but then the court date is a year later, does that matter?
No, well, let's take a look at it. A statement by a child under the age of 12. So it's when the statement was made. And the reason is, to get back to this one, is because, well, you tell me, why are statements by children under the age of 12 about sex acts on their bodies, on them, super reliable? Remember I said only super reliable statements get in. We know that when we tell about our pain, we're probably telling the truth. It's probably super reliable because we don't want to lie to the docs because we want medicine or treatment. What's so super reliable about statements involving human sexuality by kids under 12? Go ahead.
But I would think under 12 they don't know too much about sexual acts, but if they say something like that, then how else would they learn it?
Go ahead.
Yeah, basically they have no prior knowledge, so unless they've been exposed to pornography or something else that they shouldn't have been exposed to, they wouldn't have any way of making a statement like that unless it really happened.
Both of you are 100% correct. The assumption is that children less than the age of 12 are sexually innocent. So sexually informed statements are more reliable. because they are developmentally beyond their years, these statements, the assumption is that it's more likely to be true than not, that it is a statement of higher reliability because kids wouldn't know about oral sex, fellatio, cunnilingus, the dynamics and mechanics of human sexuality. Thus, it has enhanced credibility. It doesn't mean it's 100% true. It just means it's more reliable than any garden variety statement, any other statement. So the statements of kids about human sexuality committed upon them are considered to be of high reliability compared to your average statement. So is a statement that one makes to their doctor when they want treatment. And so are other statements that I'll discuss with you in a moment that are considered exceptions to the hearsay rule. Getting back to the John Thomas case. Finally, I said, you know what? This kid went to St. Joe's Hospital, to the Child Protection Program, and got a medical examination. And the medical examination produced no findings, but that's very common. But she went over there, and they took a history from her. They took a history from her to see if she had any STDs, or to see if there was any injury or trauma to her. Right? So I said, you know what? This kid won't testify. Oh, by the way, I had a confession, too. John Thomas admitted what happened. But you cannot convict a person in New Jersey with an uncorroborated confession. So that simply means if somebody confesses to a crime, you need other evidence. You need fingerprints, a video, DNA, a witness. A confession all by itself cannot be used to convict someone. So I needed to corroborate that confession. So I said, you know what? I'm going to get the medical records from St. Joe's. I'm going to put the doctor and the nurse on the stand, and they'll tell what the kid said about stepdad John coming in the bedroom and molesting her. Well, like this exception, you have to have a pretrial hearing. You have to convince the judge that the elements of the exception were met. That this is an exception case. Judge, I know what she said happened out of court, and we're offering it in court, and we want you to believe that she was molested, no doubt. This is definitely hearsay, but an exception applies. I'm all ears, Del Russo. Tell me why the exception applies. Beautiful. Put the doctor on. Put the nurse on. Judge rules, I'm not letting it in. Okay. Let's take a closer look at what happened. The girl went to St. Joe's because the Division of Youth and Family Services brought her there. DYFS brought her there. Because they were investigating the case. She was as cooperative and as interested in what DYFS had to offer her as she was in what we, the prosecutor, had to offer her. Which is to say, she was not interested at all. But nevertheless, they were accepting of the government's intervention, the family, and they went through with it. So, even though the young lady and her family didn't want to go to St. Joseph's Hospital, they in fact went to St. Joseph's Hospital, and there was an examination, as I described. Go ahead, ask your question. I thought about that. And I am a very aggressive prosecutor. They say this lady who's making a decision, as I stand here in the Trayvon Martin case, is a very aggressive prosecutor in Florida. Word is they're going to indict him, or charge him, rather. They did? Okay, he was charged. I'm not surprised. But I thought about that. You remember way back when I said, one of the things that I had to think about, and I thought about long and hard when I first got transferred to the child abuse unit was, this is an awesome responsibility. And everybody says that. It's almost trite, the statement. Oh, being a prosecutor is an awesome responsibility. Being a judge, it is. But it's cliche, right? But I really thought being a child abuse prosecutor I really thought about it. It really is an awesome responsibility. I mean, you cannot put a label, any worse a label on another human than to accuse him of molesting a child. You are universally despised. In the jail, you are beaten if you're a general population, so they segregate you to a different floor where you're among only sex offenders because you are despised by the worst of the worst. So it is an awesome responsibility. You're labeling someone a child abuser. And as I think I said last time, you have nowhere to go to get your reputation back if you're found not guilty or the government's wrong. You are forever stigmatized, forever and ever and ever, till the end of days. So it is an awesome responsibility to charge someone with child abuse. And I brought that up in the context of, how can I feel better about doing what I do? And I said, I always said, you know what? Look at the fresh complaint. Look at the first person that the kid told. If that made sense, if it came out in a way that makes sense and is logical, then I feel that there's credibility to this accusation. It's believable, and I can go forward, and I may be wrong in the end, but at least I did the right thing. Analyze how the kid told, not the cops, but the person who brought it to the cops. The fresh complaint witness. It's in that video I asked you to watch. I say it week after week. Make sure you watch that investigation video for the exam. It's in there how important it is to evaluate who the kid told and how they told before it got to the police and the authorities. That was one awesome responsibility I had, and this is the great challenge. The other one was to advocate for kids. You know, the whole purpose here is to protect this kids, and as you point out, similarly situated kids. Kids just like her or him, who might be in the same position, to protect them from this guy or gal, to protect them. If I'm wrong, if I choose not to charge, right, and I'm wrong, there may be other children who are molested, and that would be on me. So to brand someone a molester till the end of days, or to be responsible for the future molestation of an innocent child, is what we do in child abuse prosecutions and what I'm responsible for every day. You know, to borrow a phrase from medicine, when it comes to the victim, above all, do no harm. Right? Or something like that.
Yep, that's right.
And I'm in a position where the risk of harm is everywhere and every day is tremendous. It's unparalleled, the risk of mistake and harm. But, you know, not to be overly dramatic, usually you know who did it and you go forward and you get used to it. Now, back to your question. Answer her question. She says, why didn't I subpoena the young lady, compel her mother to bring her to court, and force her to testify? And if she refused to testify, what's my remedy? You may not know. Some of you may know from watching the TV. What's the remedy? Well, hostile witness is not. That allows you to ask leading questions, and that wouldn't get you very far.
That's all I learned on Law and Order stuff.
Yeah, you can ask leading questions, but you really can't ask. You can't tell the whole story with her just standing staring at you. She has to be part of. There has to be testimony, and then you can go. Well, isn't it true? You can ask leading questions. You can get assertive if you're the sponsor of the witness and they're hostile or adverse to you. But that's not what the remedy is. I mean, I just read it's the anniversary of Judith Miller, who was a New York Times reporter who went to jail. Even if you probably don't know, some of us a little older may remember that. Well, this wasn't that long ago. It was during Bush II, when she wouldn't reveal her sources in the Valerie Plume case. Valerie Plume, they made a movie about it. It's pretty interesting. Valerie Plume was a CIA operative. I think she was in Central Africa or assigned somewhere around the world battling terrorism. And somebody outed her. They said, hey, Valerie Plume is a secret agent spy who investigates terrorism. Well, that's a federal crime. It's a federal crime because bad guys will go kill her because they don't care. She's gathering data against Al-Qaeda. I mean, their professed purpose in the world is to kill Americans, you know. So by doing that, it's a federal crime. And Judith Miller, I think, that may be her name, but the New York Times reporter had information about who outed her. And she refused to testify, much like the young lady in John Thomas. And what happened to her? Someone remember? Where did she go? Went to jail. She's arrested for contempt of court. The remedy is contempt of court. You are entitled to every person's testimony. If people won't testify in response to a valid subpoena, and they don't have an exception or a privilege, they go to jail. And the jail is endless. Do you know when the jail ends? When you decide to testify. You may remember, within the last 10 years, a woman who claimed that her husband was molesting her children. I think she was a doctor from Georgetown, maybe, from Washington, D.C. area. And she secreted her children in Spain. The Spanish authorities weren't too sympathetic to what was going on in America, but somehow she got caught in America. And they said, I'm the family court. You will tell us where the children are. You disobeyed a valid order. You took the children against the laws of the United States of America to Spain. So come before me, the judge, and tell me where the children are. She says, I'll never tell you where the children are. Do you know where she was and still is? In jail. She will stay in jail until she talks. Now, having said that, it's a bit overstated because she may not be in jail anymore. I don't think she is. Eventually, the court has to decide whether this person will never talk. Despite the fact that they're in jail, there's no reasonable prospect that jail will loosen their tongue, so to speak. But jail in a contempt case is a coercive remedy designed to coerce people into saying what the court demands and what the rule of law requires in America. Get back to the case. You're the prosecutor. What's the problem with the suggestion? Go ahead.
14, 15-year-olds, can you do that to them?
You don't want to put your victim in jail.
Oh, you could.
Isn't that traumatizing?
Well, so I didn't do that. There's your answer, okay? I mean,
It's traumatizing. I didn't do it.
Now, the threat of incarceration is one thing. But we weren't about to put a 15-year-old in jail because she wouldn't testify against her stepfather because of her religious beliefs that she now shall not judge. That had Del Russo's career is written all over it, okay? I mean, that wasn't even when you're right, sometimes you're wrong. And that would not be the right thing. I wouldn't even be right. I would be wrong. Because, like I said, you have to weigh the equities here. You have to weigh what's in everyone's best interest. Now, what troubles me is, and what gave me a lot more confidence was, this guy was a 3-time molester. So, arguably, even if I did put her in the juvenile hall, there probably would have been some people who agreed I did the right thing, you know? I wouldn't do that. But it's arguable. It's not. Now, if it was unclear whether he molested her, and, we weren't as confident that this was a serial molester, but here you had a serial child molester. And I had a kid who was about to let that continue. And I owed responsibility to the children of the future. So what did I do? I said, hey man, go back to the hearsay. I don't want to get too far afield. We're in the dog park, we're in Central Africa, we're in the CIA. Back to hearsay. I had a full hearing with her and the doctors and the nurses about her statements to the doctor. She told in great detail about what her father did when she was in the doctor's office. She told it to the nurse. The doctor treated her. They checked her to see if she had any STDs, any trauma. They made sure she was well. The judge said, doesn't meet the exception. Well, what makes you... What do you think was the reason that the judge wouldn't let it in? Well, let's look at it. Let me give you the thumbnail again of the medical diagnosis and treatment exception. I hurt my knee at the doggy park. It really hurts. I want to get it treated. I have a motive. I'm going to the doc because my knee hurts. And I want it to stop. I want to stop the pain. So I call the doc. I go there. I tell the doc what happened. And I want him to treat it. And it does get treated. Assumption being, because my knee hurts, and I got a knot the size of a golf ball, and it's throbbing with pain, that I want to get it treated, I want it to get better, and I want the doc to make it better, so I'm going to tell him the truth, and he'll treat it. Therefore, the things I tell him are more likely to be true, because I want him to treat me properly, so I'll tell him the truth. Go ahead.
For the medical exception,
it has to be past or present symptoms that are allowed to be disclosed in court, not what the person says.
Well, yes, that's true. But when she goes in and describes the symptoms, that's a bit misleading. It's not only the symptoms, it's the context in which the symptoms arose. I think those are inextricably intertwined with symptoms. You know, you can't be too narrow in construing what they mean by symptoms. Because if you go, I have a knot on my knee, look at it, doc, and you see the big purpley blue black thing, right? The doc wants to treat it. His next question is going to be, what? How did it happen? So if she's in there to get her vagina checked and her genitals examined and her body checked, the doc needs to know, well, how did it happen? Right? So that's part of the symptom. But you're close. That's part of the statement of symptoms. Excuse me, the context in which the symptoms arose. Go ahead.
The youth was compelled to attend that medical exam by the Division of Youth and Family Services?
Rather than
presenting herself directly like you would do in an emergency.
Because she was involved. No, I'm saying, why would she present? Why do people go voluntarily? Because they want what?
Treatment.
Okay. Did she want?
No.
There's no evidence she wanted treatment. So the treatment motive wasn't there. Everything else was there. But she didn't go there. She wasn't motivated to go there because she wanted treatment. As you pointed out so accurately and so perfectly, she was compelled to be there by Dyfus. Now, Dr. Martin Finkel, did you guys listen to the audio?
Yes.
Dr. Finkel is a big fan of this hearsay exception. And, you know, he still thinks that it has more potential than it does in the field of forensics. Because nearly all kids are compelled to go there. Now, you could say with the littlest kids, they don't know why they're there. They'll do what mommy or daddy says, and maybe you'll get it in. Some kids may, in fact, say something. Even though Dyfus takes them there, doesn't mean they don't want to get treated. The thing is, you need to be able to demonstrate that the kid has some interest in this process. Some. This kid had none. Zero. Zilch. No, nothing. And that made it different. But in many cases, you may be more similar to this kid than the hearsay exception. Because when Dyfus brings you, you're starting out with no treatment motive. Now, Finkel, Dr. Finkel, Martin, would get around this by saying, well, Del Rousseau, they may not have the treatment motive when Dyfus drives them there. But when I tell them, listen, I want to check you out from head to toe. I want to make sure you're okay. I want to make sure that everything works and you can have babies one day and get married and meet a boy or a girl or whatever and you can be even healthy. I want to make sure that you don't have any diseases or illnesses. I'm going to check all that out for you. Do you want me to do that? Is that something you want to know? Tell me what you're worried about. And I bet you even the girl in the John Thomas case, as much as she shall not judge, as much as she had a firm belief in her religion, she had some concerns about her body and about the consequences of what this guy did to her. Because just because she wouldn't testify, and just because she believed that people should not be judged, doesn't mean she's not a person who didn't have concerns, right? So if I was able to get her to articulate that, or if Dr. Finkel, or in this case it was Dr. Albert Sands at St. Joseph's Hospital, if those doctors were able to get this girl to articulate that, then we might have had a case. So Finkel would say, Dr. Finkel in South Jersey would say, I make sure I go through this thing with them. Now, are you better? Are you more likely to get in a medical diagnosis exception in Dr. Finkel's practice? Yes. Will it win the day in all cases? No. Will it win the day in some cases? Maybe. But he understands it, and he tries to present to the child. He tries to take a history from the child, communicate with the child in a way that allows them to express their concerns and their symptoms because it's in their best interest, and they want to make sure they're okay. And he tells them, I'm here to make sure you're okay. He's got something you want to do. And I don't think there's any kid in the world who doesn't want to know whether they're okay or not. Even that girl in the John Thomas case. So Finkel is onto something, but you need to make sure that happens. And you need to make sure that it happens in the way that the court needs. That somehow we can infer that the kid has a treatment motive. That's why she's at the doctor's office. When Dykus drove them there. And it never crossed their mind until they got there. Okay, let's take a look at a couple of other hearsay exceptions. Going to chapter, I think it's 5 or 4. Yeah, it's chapter 5. Maybe not. Yeah, chapter 5 talks about hearsay, which we've been talking about this evening. We talked about the tender years exception. We talked about the fresh complaint of rape. We talked about last time that was for adult rape victims when they make a complaint shortly after the rape occurs, and it really has to be fresh. That's not really a hearsay exception, but it's something that is said out of court. We just talked about the medical diagnosis or treatment exception. Let's take a look at this state of mind exception, and it's in your book at 161. These kind of exceptions are generally admissible. It's rather complicated, and as Professor Meyer says, we're not going to unravel all the mysteries of the state of mind exception. But where people express fear or pain or discuss their feelings, like affection or fear or not liking something, those things are generally admissible as an exception to the hearsay rule. For example, if they brought in a dog lover from Brookdale Dog Park who said, Del Russo was screaming, my knee, it's killing me, my God, I hope I didn't fracture my kneecap or something. That statement of pain, as I'm experiencing it, is considered, for a few reasons, an exception to the hearsay rule. First of all, it fits this state of mind exception. Again, just to understand basically what state of mind means, when you say something about how you're feeling, let's just put it that way, and that covers nearly everything in the state of mind. You know, I love my son. My knee hurts. I'm afraid to walk down the street and cross Route 80 at night. You know, these things about how I feel, my fears about crossing Route 80. I don't like balconies on high buildings. My knee hurts because it just got banged on the ground. These kind of statements that describe your state of mind are generally exceptions. Okay? Now, when we talked about the tender years exception, remember the third element or the fourth element of the tender years exception, kids under 12, sex act upon them, was that the judge finds the statement is reliable. And in Professor Meyer's book at page 164 and 165, there are examples of what courts look at to determine whether a child's statement is reliable. Well, the first and perhaps most important thing, well, not most important, but one of the more important factors that the court looks at is whether the statement was spontaneous or not. Children who make spontaneous statements of abuse are more likely to be perceived as credible, more likely to be believed, more likely to be telling the truth than kids who make statements about being abused in response to questioning, especially bad questioning or misleading questioning. So the court looks at spontaneity. Okay? And to give you an example, or to contrast these things, I'll tell you about Gabriella, who's staying by her Aunt Cynthia's house. And Gabriella is watching a movie called Something About Amelia. And in this film, the actor, Ted Danson, plays a man who molests a little girl. And it's somewhat graphic. It came out in the 1970s, but it was one of the first films, a made-for-TV movie, by the way. One of the first films that really looked at incest in a legitimate and credible way. In any event, here's Gabriella watching it with her Aunt Cynthia, and Aunt Cynthia notices that Gabriella looks sad and sullen, and is acting a little weird, and they're simply watching one of these movies on Lifetime. There was no Lifetime back then, but probably Channel 7 or something. And she says, Gabriella, what's the matter? No, nothing. It's okay. Everything's okay. You sure? Yeah. All right. They watch the rest of the show. Gabriella doesn't say anything, but the next day, because she's staying over her aunt's house, hanging out with her cousins, she says, can I talk to you, Aunt Cynthia? Remember we were watching that show about that guy who touches his daughter? My father's doing that to me. Right? It comes out spontaneously. It comes out in context. This is why I say talk to the fresh complaint witness. Talk to the first person that the child told. You can size up how it came out, and you can say to yourself, does that make sense? Is that credible? Is that believable? Do I have something here? Doesn't mean it's 100% true, but it means you're starting out on good footing, with a good foundation. In that scenario I just described to you, Gabriella's statement to Aunt Cynthia makes sense to me. It's believable. She's crying. She brings it up. The aunt does nothing. They're simply watching a show that might be likely to produce a statement by a child about this, a show that might enlighten a child about the fact that incest is wrong and shouldn't be tolerated, and that she's not alone, and it's okay to tell. Having seen that show, and then spontaneously telling her Aunt Cynthia about it in an emotional way, makes me believe that it's credible. Does that make sense? Okay. It's spontaneous. The first thing that Myers tells us to look at, actually it's Idaho versus Wright, Supreme Court of the United States tells us to look at, is spontaneity. I'm going to switch the facts around to show you the opposite kind of disclosure. The polar opposite of Gabriella's statement while she watches the movie about incest to her Aunt Cynthia. The opposite. Imagine, if you will, Grandma Rosie. Grandma Rosie's a nice lady. Grandma Rosie is among these grandmas who are the salt of the earth. They take care of their grandchildren when their children can't take care of their grandchildren. The grandmas of the world sometimes care for our kids when the moms can't care for the kids. And that's exactly what's happening in this hypothetical I'm offering you. Grandma Rosie's caring for her little granddaughter, Daniela. Daniela's 4 years old. Now, Mom doesn't have custody of Daniela. Grandma Rosie's taking care of her, although Mom is out there and she has her own apartment and she visits her daughter. Grandma Rosie does not like Mom's new boyfriend. He's got a weird look and funny eyes, and she heard from some ladies at the beauty parlor that he touched a kid once when he lived in North Carolina. And she knows for a fact that he smokes weed, marijuana. She knows it for sure because he admitted it. She don't like her daughter's choices in men, and she certainly don't like this guy, Jerry. Don't like him at all. So Grandma Rosie is bathing Daniela one day. She's got Daniela in the bathtub, and she's scrubbing her down, and she's goofing around with her granddaughter, and they're having a grand old time. And she notices, as she looks at her daughter's vagina, her granddaughter's vagina, she notices that it looks a little bit reddish. As it should, I imagine. But nevertheless, she determines that it looks different. Its hue is a bit different. It's redder than normal. She is suspicious. So she says to little Danielle, age 4, somebody's been touching Grandma Rosie's stuff. Daniel goes, Grandma Rosie's stuff? Yeah, somebody been touching Grandma Rosie's stuff. Somebody touching Grandma Rosie's stuff? Yeah, that's what I'm asking. Big Jerry touched Grandma Rosie's stuff? Big Jerry touched my stuff? Big Jerry touched your stuff? Huh? What? Yeah, Big Jerry touched your stuff? Yeah, Grandma, Big Jerry touched the stuff. Okay. We get reports of molests from DIFAS all the time, and from schools and police departments and everywhere else. I'm going to tell you how this referral will look on paper when we get it. I'll get it. My sergeant will get it. It'll say, 4-year-old Daniela Pasillo disclosed to her maternal grandmother that her mother's boyfriend, Gerard Pasillo, also known as Jerry, and in parentheses, who is a drug addict and molested a child in North Carolina, digitally penetrated her while in the custody of the mother on more than one occasion. My God. A man fingered a 4-year-old child in her vagina. This is outrageous. Get a detective on it right away. Bring in the kid. Arrest the suspect. Let's move. Right? It's an outrageous accusation. However, we need to go back and analyze what have we been telling you over and over again. What have I said on that video I asked you to watch? I tell you, evaluate how the information came out. Scrutinize the fresh complaint. Hey man, Grandma is a good grandma. Grandma didn't do anything wrong. Grandma will tell you, if I sit there, who did the talking? I did the talking, because I don't trust that Jerry. You know, he molested a kid in North Carolina. I heard about that, Grandma. Tell me more about what happened. I asked her, is someone touching Grandma's stuff? And what did she say? She said, what? And I asked her again. And I asked her, I know, he no good. She's always making bad decisions. He's no good. You guys going to lock him up? I don't know, Grandma. We need to know more about what happened. So, if you're going to apply the Supreme Court's analysis here, or you're going to apply your own analysis to determine whether this disclosure makes sense, whether it's logical, or whether you need to take the next step, you got to look at this one and go, you know what? We need to look further before we lock up people or take kids away or point choosing fingers at Mom or Gerard or anyone else in the case. Was that a spontaneous statement? No. This is what now look at the two examples I gave you and let's look, you don't have to look at 164, I'll read them to you, but I'm looking at 164 of your book. Let's look at what the Supreme Court said, how to size up kids' statements. Spontaneity. The Something About Amelia case with the TV movie. Spontaneity? Was the kid spontaneous?
Yes.
Yes. The grandma, I call them Dr. Grandma cases because they analyzed the vagina. Oh my God, it's red. Dr. Grandma case. Spontaneous, the kid's statement? No. Next factor. Statements elicited by questioning. The movie of the week case with Gabriella? No. Elicited by questioning? No. That's a good thing. Dr. Grandma case? Yes. Now, this is not part of the analysis that we can do with these hypotheticals, but the other thing the court says to look at is consistent statements. So if we talk to Daniela, the 4-year-old, again in a forensic interview, we want to compare what she says in a forensic interview with what she told Dr. Grandma. And if the Dr. Grandma case turns into he made me kiss his pee-pee, well, did he put his hand, was there a time he touched you somewhere on your body? No. Was there a time he touched your body with his hand? No. Did you tell Grandma that he put his finger on Grandma's stuff? No. Well, now you got an inconsistency there, right? She's saying he kissed his pee-pee here. This was additional penetration case. Doesn't mean it didn't happen. Doesn't mean we cannot explain inconsistency among children. Simply means there's an inconsistency. And when people are inconsistent about things that happen, we say, hey, maybe they're not telling the truth. We expect people to be consistent when they tell the story multiple times. Not exact. Then you know you got a liar. I tell that to juries all the time. Inconsistency is part of the human experience. You know, the same person doesn't remember the same thing the same way when they repeat it. You don't expect them to be inconsistent about big things, about material things, about important things. Those you expect to be consistent. But little details, people mess up all the time. It's when people don't mess up and everything's exactly the same, you know you got a liar. Because that's not the way it works. You know? So consistency is important, and you need to size it up, right? The child's state of mind and emotion. Now, in the Gabriella case, who's watching the movie with Aunt Cynthia, as I presented it to you, what was her emotions like when she told? She's crying, she's getting choked up, she's upset, she's sad. 4-year-olds, you really can't put a lot of stock in their emotions. It could be true that Uncle Jerry or Pop Jerry or Mom's boyfriend Jerry touched her vagina, but it's no biggie to her because she don't understand what's going on. She's too little, right? So the emotions when telling is not that helpful with a preschooler. Just isn't. And we can't misread emotions either, because emotions, depending on how many times somebody told something or how they feel about what happened, can run the gamut. But we want to look at it too. We need to look at emotions to size up whether it's credible. If they have any developmentally unusual sexual knowledge, okay. Now, if we brought in, despite what Grandma Rosie did, if we brought in Daniela, age 4, and we did a forensic interview, and she said, Big Jerry put his finger in my chachi. Tell me more about that. Jerry did it. He went in the bathroom and he got the stuff and the Vaseline. He went in and got the Vaseline. He put it in and he put it in the mouth. He licked his finger when he was done. Well, that is unusual sexual knowledge for a 4-year-old, right? So despite the fact that this case was born in a problematic context, the interview by the child raised it. It made it more believable, simply because, as I changed the facts, she offered developmentally unusual sexual knowledge. And you'd be surprised, we get quite a few cases where the offender puts his finger in his mouth after that, tastes it, smells it, does that kind of thing. And that's a good day in prosecution business, because that shows kids don't know that. You don't get that from TV, you don't get that from crazy moms who are coaching you. You get that because it happened. So you're looking for that. And of course the other biggies are the sights and smells of human sexuality, the taste of semen, the consistency of semen, the words that people use. Bad guys and offenders say things that kids wouldn't know. Use your best imagination to think how men and women interact and the things they say. Over text. They bring it on home. I don't know. Do me harder. Oh, baby, that feels good. Harder. Whatever you can think of. When 5 and 6 and even 7 and 8 and 9-year-olds offer that, you go, hey, that's good stuff. Because that is developmentally unusual sexual knowledge. And it is also the close cousin of that element or that factor is idiosyncratic detail. Idiosyncratic detail. I don't know if it was my case or Chris Freed's case, where the child was asked how it felt when some molester put his penis in her mouth, and she said, hairy. It felt hairy. The salient detail to her was her face making contact with pubic hair. At least that's what we argued, and that's what made sense. Because to describe that as hairy was interesting and persuasive. And the jury found it persuasive as well. Using developmentally appropriate terminology. So you take the 4-year-old and go, when she says, yeah, and then he put his dick in my pussy. Then you're like, okay, is this coached? Is this from porno movies? Is this from some alternate source? Or did she live this and experience this? We expect that kids are going to use language that's appropriate for their age. So that's what the court looks for as well. Developmentally appropriate language, and contrast that with developmentally inappropriate language. And these are the kinds of things the court says to look at when deciding whether what a child says out of court is credible. Here are 2 others that the court tells us to pay attention to. Whether the child has a motive to lie. If there was a history of Danielle trying to get Uncle Manny out of the house, right? Then we want to know that, because that child might have a motive to lie. And we need to know that. And that helps us evaluate whether they're being truthful or not. The other thing that I find very persuasive and very helpful is when kids correct the interviewer. So, in New Jersey, all of our interviews are recorded on video. If the child corrects the interviewer, then you can conclude, or infer rather, that they're not being misled or they're not answering questions in a way simply to please the interviewer. If the child corrects the interviewer, it shows us that they're paying attention and that they will not simply agree with something or say something because the interviewer suggested it. It's a very powerful factor to look at in a forensic interview. Which reminds me of a case, I think I could bring that up right now. We have a recent 911 call, which we're investigating right now. In this case, the little girl calls 911. She sees on her father's computer a video. And in the video, her father's touching the scrotum of her young brother. And she sees it on his computer. But she calls 911. And I'm going to overstate it a bit because you'll get to hear some of the audio in a moment, I think. The interviewer, she goes to the interviewer, I called because my dad was touching my brother on his thingy. And the interviewer goes, what? My dad was touching my brother on his balls. Huh? What? Your brother's touching you? No! My dad is touching my brother. So that is as correcting as you could be, right? She's clarifying and straightening this lady out, and she's not agreeing with what she says. She knows what she saw, and she's expressing it. And I think in a way that's very credible.
911, where's your emergency?
It's at, I think it's at, yeah.
What's the problem?
My father has bad videos of, and he's making my brother touch his thingy.
What?
He's making my older brother touch his balls.
How old are you?
I'm 9 years old.
What's your name? Are you home alone with your brother touching you?
No, my dad was touching my brother.
How old is your brother?
My older brother, he's 11.
And they're home right now with you, and you watched them do this?
No, it was on his computer.
You turned the computer on and you saw your father doing this?
No, I didn't turn it on. When I woke up in the middle of the night, and my dad was asleep, but the computer screen was still on, and there was a video of it.
And you saw it?
Yeah.
And it's your brother in the video?
Yeah, and
That's a good example of the interviewee correcting the interviewer. And it's kind of an interview. It's on the phone. 911's asking her questions. And she's not biting at what the 911 operator thinks is happening. She's correcting her, and she's emphatic about it. And you could feel it in her emotions about what she saw. And it's so unusual and idiosyncratic, right? I mean, even if you're coached or making it up, you're going to make up you saw a video of your father. Why not say I saw my father in person touching my brother's testicles or balls or thingy, as she calls it. What else? What was the first way she characterized it? In age-appropriate language, right? I saw him touching his thingy. And then to clarify, she had to explain it better. Okay. Anyway, so when I was talking about all these things, spontaneity, idiosyncratic detail, whether the child corrects the interviewer, that's so we can determine whether a child's out-of-court statement offered under the tender years exception is reliable or trustworthy. And that works pretty well for any witness, as a matter of fact, not only kids. But it's the thing that those are the factors that the Supreme Court has asked us to take a close look at when it comes to hearsay statements by kids. Okay? Now, there are two other examples that I want to tell you about involving hearsay. statements that are considered super reliable. One is what's known as a dying declaration. If you believe you're about to die, and I think I told you this last week, you're more likely to tell the truth or make a statement that's true because you're about to meet your maker. Because you don't want to die with a lie or an untruth on your lips. The assumption is that people who are dying, and they know that death is imminent. You could be missing a leg, your arm could be hanging off, you could have 400 wires in you, you could be on an artificial respirator, you could have a machine that helps your heartbeat, and you think you're going to survive. Doesn't apply. What's important is you think you're going to die. Okay? You might have just banged your head and had a mild concussion, but if you think you're going to die and you believe it and you make a statement, it's admissible. If the question is whether the person believes that death is imminent. And if they do, you're more likely to tell the truth when you're on death's door. And whether you believe in a God or a deity or whatever, I don't even think matters. Some would suggest that this exception is anachronistic, that it is a leftover, that it's a vestige of another era where people cared about going to heaven, and that there's more atheists and less people believe in God, and the world's different, and all that. I don't think it much matters. I just think that people want to hedge their bets. They don't want to die with a lie on their lips. It's just as simple as that. Whether they believe in a deity or not, I think most people would agree that it's not a good time to become a lie as you're about to die, no matter what your belief system is. I think that's a general inclination among humans, not to lie when they're dying. Because of the unknown, let's put it that way. Now, another example that you might see in child abuse cases, you might have even had it in this 911 call. The thing that was relevant in that 911 call was she figured this out at 3 in the morning. Her mother said, we'll talk about it in the morning. The parents are involved in some kind of litigation in family court. But the kid says, the mother says to the kid, okay, I heard you, relax. In the morning, I'll tell my lawyer about it and we'll see what we got to do. I don't know. That's crazy what you saw. It's terrible. But I'll talk to my lawyer in the morning. The little girl's like, okay, she goes to sleep. Well, when she gets up about 7:30 in the morning, she starts calling her mother's cell phone and her mother's not picking up. Now she starts freaking out because she thinks her father knows that she knows, and she told her mother. So she gets really scared and she dials 911. Now that is possibly what we call an excited utterance. It's a close call on that one because we listen to it. But when you make a statement, when you are under the stress of excitement, when you are anxious, and totally excited, and you don't have time to reflect, in the middle of a highly anxious, traumatizing, or stressful moment, you make a statement, it's usually admissible. And the reason it has super reliability is the person doesn't have time to think, or lie, or fabricate, or mess it up with the filters of their emotions, or let their motives influence what they have to say. You just don't have time to fabricate. It's as simple as that. If you say, oh my God, that car ran over that little doggy. Oh my God, there was just an explosion at the Meadowlands. I seen the whole thing and it looked like a plane. If you're screaming and yelling and hollering and you're upset and you're nervous and you're jacked up and you're anxious and you make a statement, it's almost always going to be admitted as an excited utterance. Now, the courts have even extended it. Usually it has to be at or about the time that you're excited. But the courts have allowed statements that take place minutes, sometimes hours after it happens. Imagine that little girl who sees this at 3 in the morning and the mother doesn't pick up the phone. And then she goes in her bedroom. I'm making this up. There's no facts in that case like this. But she goes in her room and she's afraid her dad's going to find out. She's afraid she saw it. And she's wondering what's going to happen to her. And she's scared. That's 3 o'clock in the morning. She finally gets her mother on the phone. I'm changing the facts. Finally gets her mother on the phone, 9 a.m. Mommy, I don't know what I saw. Dad, touching Billy on his balls. That's 7 hours later, whatever, 6 hours later, right? Is she nervous and excited? Is she nervous and excited because she saw that video? Yeah. So, the proximity of the statement to the exciting event depends upon the facts. Usually it's at the time. Oh my God, a plane just exploded over the Meadowlands. Did you see that? It crashed right into the radio tower. Well, usually it's at the time it's happening. That's when you're really jacked up. But you can have excitement later for whatever reason. It could be what they call a rekindle. And with little kids, the courts have felt that statements that are made in an excited fashion, sometimes days or weeks or months or years later, may be admissible. But the general rule about excited utterance is at or about the time it's happening. And the challenge is to document why it's an excited utterance so that the court can agree that it's an excited utterance and let the statement in. I'm going to try to show you a video clip, and I want you to write down I want you to make a note of the facts about the statement and the person making the statement that you believe demonstrate it's an excited utterance. Remember, it has to be a statement made under the stress of nervous excitement at or about the time they witness it. So we need to show stress, nervousness, excitement, a statement, and a precipitating event. Something that made them excited.
What are you doing? Signal 1054, we either middle down, Bleecker and 7. You're failing on.
I'll watch it. Let you watch it again.
Signal 1054, we either middle down, Bleecker and 7.
Okay. Do we possibly have an excited utterance? What makes you say that? Go ahead.
She had like a stressed look on her face and she was breathing heavily.
Okay. I like breathing heavily. I like breathing heavily. I like that observation. I like stressed look on her face, but what makes you say that? What was her face like? That's a conclusion.
She just looked very surprised and she was like almost anxious for them to hear her out. Her eyes were like coming out of her socket.
Stop right there. Now you're telling me facts. That's good. You said she had a surprised look. You said she looked startled or whatever. I didn't even say that, but some other word. That's okay. Those are conclusions. Once you tell me her eyes were big and expressive, they looked like they were popping out of her head. That's good stuff. That are observations that anyone can think about and judge on their own. What else did you see? That made you believe she was excited?
She was in like an exciting situation. Somebody got shot. So.
Well, you had a good precipitating event, right? This shooting of another human who's laying in the street, perhaps dead. So you remember I said you need a precipitating event, something to make you excited, and that pretty much fits the bill. The man was shot, and he's laying in the street. Now, we have eyes almost popping out of the head. You said something else about her.
She was
Breathing heavily. That's good, concrete language, right? Rather than, she was really excited. She was all excited. She was stressed out. Those are nice things, but they don't tell me how she was acting. Her eyes bulging out of her head. Her, how'd you say her breathing was? Her breathing heavily tells me something. It's descriptive. What else? Go ahead.
The time right after it happens. The event.
You got proximity. You got a precipitating event, and you got a statement made shortly thereafter. Almost contemporaneous. Almost at the same time. What else told you she's excited?
She like blurted it out as soon as she saw the cops.
As soon as she saw the cops, she didn't reflect for a moment. What is that similar to? What factor would that be in Professor Meyer's list from Idaho versus Wright Supreme Court? Spontaneity, right? It was spontaneous. That's what you just told me, right? She blurted it right out. And that's good. When you're evaluating a hearsay exception, an excited utterance, spontaneity is pretty good stuff. You tell me, what else did you see about her?
It's just like he was going that way. She said the exact street name.
She said the exact street names, but then how does that tell us she was excited? Think about it. You saw her. What was her body doing? What did her face look like? What about her jewelry? Was there anything that takes us there and shows us this is a jacked up, excited lady?
Waving her arms.
Was she?
Yeah.
Waving, that's good language, right? You need to paint a picture of a human who's excited. This human. So far we got a lady whose eyes are popping out. She can't catch her breath, and she's waving her hands around. Now, she wasn't that animated, but she was moving her hands. That's good stuff. Give me more.
She grasped the details of the right hand. She doesn't really.
Yeah, how does that give us excitement, though? It's good stuff. I mean, we need to know that, but I don't know that it communicates excitement. We need to know that. That's good. It shows her powers of observation are good. Thus, maybe it's more reliable, but I'm looking for things she did or things that you observed that communicate excitement about her body. We got some big ones already. You could say she was stuttering. That's a good observation. I would say her speech was she spoke haltingly, catching her breath in between the statements. And she did. She didn't stutter, but it's subtle. I've seen this clip a million times. It's subtle, but she's not speaking start to finish in a cool way. She is, I wouldn't say stuttering, but it's coming out in a jagged way. That's a good observation. That's important too. Eyes bulging out. Can't catch her breath. Waving her arms. Speaking haltingly, almost stuttering. Go ahead.
How about the nature of the event as a whole?
It is an event that would cause excitement. Yeah, and it was done. That's important. Go ahead.
I want to say, like, she touched, like, didn't she grab onto the cop's shoulder? Like, you know.
She
like,
was unsteady.
yeah,
She
like,
was emphasizing herself. She did. She was kind of
Like,
leaning
kind of
on.
like for comfort, like, to grab
Yes.
him.
Yes. Excellent. I think that communicates anxiety or excitement. Anything else? What about her jewel? Go ahead. Professor Curcio has watched this clip with us many times, and she points to, and I like this fact, something about her jewelry that showed you that this was an animated statement. Go ahead. What was jingling? Yes. I mean, yes, her earrings were going. And that showed you she wasn't simply, hey, you know what happened? I saw this guy, he shot somebody. If that happened, her earrings would be, they'd be just hanging there. Her earrings were flinging back and forth. They were swinging. Quickly. Her hands were shaking. We got a list of 7 or 8 things right now that show that this lady was excited. And that speaks to documentation, but it also speaks to understanding how a hearsay exception works. This hearsay exception is predicated on excitement, and you guys just deconstructed that and told me why it was an exciting event. And my ruling is easily admissible. Any questions about hearsay and hearsay exceptions? Okay. Next thing I want to talk about is this case called State versus PZ. And that's something in your learning module. State versus PZ has to do with the Miranda warnings and whether DIFAS workers have to provide criminal suspects their Miranda rights or their Miranda warnings. And I'll tell you in a moment what those warnings mean and what it's all about. First of all, we've learned earlier in the year about the United States Constitution, the agreement between the citizens and the government about how we want to be ruled. In that Constitution are the Bill of Rights. The Bill of Rights is a list of limits on governmental power. Two of the more important limits on governmental power are in the Fifth Amendment and the Sixth Amendment. And the Miranda warnings, that advisory that you hear over and over again on television, on these police shows, arose from a case called Miranda versus Arizona. Miranda was a two-bit hood, a criminal out in Arizona, and he was arrested and prosecuted, and it was a pool hall burglary or something like that. It wasn't the crime of the century, but his case is forever known for the required advisory that police must give to suspects when they're going to question them. And that advisory has two central elements. It notifies persons that are in custody that they have a right to not talk. They have a right to remain silent. They have a right to not incriminate themselves. That's the Fifth Amendment. The Fifth Amendment says no person shall be forced to be a witness against themselves. So we can't take a person and force them to testify against themselves or give information against themselves. That's the Fifth Amendment. The Sixth Amendment says every person accused of a crime shall have a right to an attorney to help them defend themselves. Fifth Amendment, you have the right to not speak. You don't have to talk to the government or the cops. Sixth Amendment, you have a right to a lawyer before you talk to the government or the cops. Fifth and Sixth Amendment, that's what this Miranda thing is all about. Now, you will notice on television shows, they read the Mirandas or they tell suspects the Miranda rights anytime they take the guy in custody. They got their knee in the back of his neck. They jumped over 2 or 3 fences. They're in a schoolyard in the soft grass and the gravel, and they're yelling the Miranda rights at the guy. That doesn't happen. That's not real. In the real world, he'd be arrested. And when you want to question the person, then you read in the Miranda rights. The Miranda warning is about one thing: questioning people. If you're going to question a suspect who's in custody, police custody, you have to tell them the Miranda rights. Yes?
You're talking about Miranda versus Arizona right now, right? You're not talking about this case.
Well, that Miranda versus Arizona is mentioned in this case.
Oh, okay. I just want to make sure.
Yeah.
Miranda versus Arizona is the one that started the whole Miranda rights.
Correct. Yep. You have to remember that the Miranda warnings apply to custodial interrogations. That's your buzzword. Words. Custodial interrogations. And I said it a moment ago, when people are being questioned. Being questioned is also known as an interrogation. Custodial interrogations. When you interrogate somebody, you give somebody the interrogation, the third degree they call it sometimes. Sometimes people interrogate other people. It has nothing to do with police work. You question your kids, you question your spouse, you question your parents. Some people would call that interrogation. An interrogation is loosely defined as an accusatory questioning, an accusatory interview. Okay? So, the police, if they're going to simply arrest somebody and not ask them questions, ain't no Miranda. The Miranda is about questioning. It is a preamble. It is the beginning. It is the first thing we do before we question somebody. Miranda essentially says this: listen, dude, I'm going to question you. But you don't have to answer my questions if you don't want, because there's this thing called the Fifth Amendment, and it says that you don't have to answer my questions. So even though I want to question you, if you don't want to answer my questions, you don't have to answer them, and you can tell me to stop, and it's over. I won't question you. The other thing is, if I ask you questions You could always say, I want to talk to a lawyer before I answer your questions. So I'm going to ask you questions now, but you don't have to answer them until you talk to a lawyer about this thing. It has to do with questioning. Pure and simple. It's about when the government questions people in custody. Questioning people in custody. Or as I said, a custodial interrogation. So if there ain't going to be any questioning, there ain't going to be any Miranda. So, to put it more formally, when someone is in custody, I keep saying custody, that means that they're at the police station, or they're charged, they're in handcuffs, they're in jail, they can't go where they want to go. The police are calling the shots now. They bring them down to the station, they put them in a small room, they want to talk to them about what happened, and they can't go where they want to go, they go where the police want them to go. That's custody. You're in custody. The legal definition is when your freedom of movement is significantly curtailed. When you can't go where you feel like going, you're in police custody. If the cops want to talk to you, you say, listen, I feel like going to the mall and getting a Cinnabon. Can we do this later? They go, no. You're in custody. If they go, okay, we'll catch up with you later. What time do you get out of Cinnabon? You're not in custody. And you don't get Miranda.
But anything you said, I'm just saying, if you're not in Miranda, can they use that against, can they bring that up later on?
Anything you say can be used against you.
Even though you're not in custody.
Well, if you're not in custody, then there's no Miranda, and they can use it against you. Suppose a guy walks up to a cop on the beat in front of a bank on Main Street in Patterson. He's like, Officer Mott, Bill Mott, how you doing? I gotta get this off my shoulders, man. I beat up my wife last night. She's in bad shape. I should have done it. They charge him with aggravated assault, domestic violence. We're going to use that statement against him. Nobody interrogated him. He wasn't in custody. Even if Bill Mott said, what did you beat her with? I beat her with my hand, and then I went in the garage, and I got a tool, and I hit her with it. That's an interview. It's an interrogation, but he's not in custody. He's on the street corner. The cop probably is upset that his afternoon has been spoiled by having to make this arrest. So yes, those statements that were made to a cop, but not in custody, would be admissible if the government wants to use them. Custodial interrogations are not admissible. Now, the courts have looked at the tricks that police officers try to play after the Miranda ruling, and they said, you know what? Even when you don't ask questions, if you do stuff to try to get people to say something, if what you do is what the courts call the functional equivalent of interrogation, we're going to hold that the Miranda rule applies. I'll give you an example. There's a famous case called the Christian burial case. In this case, the police knew that the suspect was a little slow. He had some cognitive limitations, some mental disabilities. But he was still competent enough to be held responsible. So they picked him up, and they had him in his car. And I'm not sure if this is the case where, I think it was, he was represented by a lawyer too, and the lawyer said, don't talk to my guy. So he invoked his Fifth Amendment right not to talk and his Sixth Amendment right to a lawyer. So the cops know they're not allowed to question him. He's clearly in custody. He's cuffed and shackled at the legs in the back seat of the car. But they knew that he was a little slow and that he fancied himself a reverend, man of the cloth. He was very religious. So they referred to him the whole ride as Reverend. Hey, Reverend, you want to stop at Wendy's and get something? And he liked that. He's into the cops calling him Reverend and respecting him. So they go get some burgers and they're driving. It's cross state lines, a few hours or more drive. Finally, the cop in the front, the two cops in the front start talking about the kid's body because he was accused of murdering a little child. And then one cop says, Steve, it's really a shame that that little boy is never going to get a Christian burial. And the other cop says, I know, Scott, we're never going to find that little boy's body, and, I hear it's going to be a snowstorm this Friday. Those parents will never be able to look their little boy in the eye and bury him like good Christians. The snow will pile up and we'll never find that kid's body. Yeah, it's a shame. He'll never get a Christian burial. In the law, this is known as the Christian burial speech, whereupon the guy in the back, the accused, who's hogtied and in complete custody, directs them to the body, helps them dig it out, and he's charged with the homicide, the murder of this boy. And they used against him the fact that he knew exactly where the body was buried. Reversed by the Supreme Court, because it was a violation of his Fifth and Sixth Amendment rights. He invoked them, and they conducted a custodial interrogation. Well, the prosecutor would say, Judge, they didn't interrogate him. They said, come on, man. No, they didn't say that. They said, this is the functional equivalent of an interrogation. That discussion in the front seat was calculated to get him to say something. So whether you use words and say, hey, dude, where's the body buried? Or whether you use some Abbott and Costello routine in the front seat, if it's designed to get the guy to talk, it's interrogation. That was the whole purpose of that, to get him to talk. And you ain't allowed to get people to talk without reading them their rights and a complete waiver of those rights. And he didn't have that either. Case closed. So that's how important the Miranda decision is. This case is about whether the Division of Youth and Family Services, whether DYFS has to read suspects who are in custody their Miranda rights. Yes.
So even if he was to say, I know where it is, and even brought them to the location where the body was buried, it wouldn't count? Even if they
No, not even if. That's exactly what happened. The answer is yes.
So no charge would be against him, even though he should.
Well, you could charge him, but you're not going to have that evidence. The statements that he made about finding the body. I'm sure he said, go up here behind this ravine and turn left by exit 42 and, it's buried in a shallow grave near the foot of the creek.
So you can just use against him that he knew where the body was?
No. You can't use any of that. Everything he said and all of the fruits, all the things that he did that arose from their improper interrogation are out the door. But that's a good question. The remedy is suppression. When the cops violate the rules, you're not allowed to use what you learned from that violation. They call that the fruit of the poisonous tree. So the poisonous tree is the statement that's illegal, and the fruit is what you learned from the illegal statement. So if you imagine this tree, any fruit you pull off it that arose from that illegal statement, if they went to the body and they found the murder weapon buried there, and then there were fingerprints in the murder weapon, they brought the gun to the state police lab, and they found fingerprints, and they're his, and there was a couple of skin cells on there, and they ran it in the DNA database, and it was a perfect match for his DNA. Right? All of these are fruits that they would not have had if but for the illegal question. So yeah, you're onto something there. But the answer is, unfortunately, it's all suppressed. And that's to deter, to discourage cops from violating people's rights. Not only cops, government, law enforcement, police officers, and the like. So the question becomes, in children in justice, is that do child protection workers have to abide by this rule? No. And the answer is maybe. Tell me why in PZ the court said the Miranda rule did not apply. He was not in custody. They were where? Where did the DYFS worker interview him? Was it in a jail? Was he hog-tied in the backseat of a police car? Was he in a holding cell with one little light bulb hanging over his head? So his own home. Now, some may say, it shouldn't apply to DYFS at all, even if he was in the jail cell. But that's not what the two other cases said. In reading this case, you learned about two other cases, Helua and Flowers. I'm going to scroll down on the big screen and highlight this paragraph at page 1 of the excerpt I gave you. DYFS workers were acting as law enforcement officers when they questioned defendants who were incarcerated. In State versus Flower, that happened, and in Hilua, the defendant had been advised of his Miranda rights when he was arrested for sexually assaulting his 2 daughters. He was subsequently interviewed by a caseworker when he was incarcerated at the Middlesex County Correction Center. Similarly, in Flower, the defendant was interviewed by a caseworker when he was in the county jail after having been arrested and charged with sexual assault of a 3.5-year-old child. That's not PZ. PZ, they went to his house. He was in his own kitchen. He got to drink his own beverages from the fridge. He simply wasn't in custody. So the answer is, basically the same rules apply to DYFS workers as police. If you're conducting an interview about the facts of a crime and the person's in custody, they need to get their Miranda rights. Now, I've trained many DYFS workers here. They'll say, we're not allowed to do that. We're not trained to do that. And they're right. And they shouldn't do that. So the lesson is, DYFS workers, when they want to talk to a suspect in custody, they need to call the prosecutor or the police. And then they'll collaborate on that issue. And they do. And they know that. But once in a blue moon, a DYFS worker is in a context that they didn't anticipate. Maybe the prosecutor already arrested the guy, and he's sitting in the holding cell at the prosecutor's office, and they go talk to him back there, and they really didn't think about it, and they learn something. If that guy can get his Miranda rights, it's not admissible. What he says, and the fruits of what he says is not admissible. So the general rule is for DYFS workers, just like police officers, that when you do a custodial interview of a suspect, they need to be advised of their Miranda rights. And practice in New Jersey is for DYFS workers not to issue Miranda warnings. So they don't interview suspects in custody. Simple as that. Unless they talk to the prosecutor. Now, what they learn can be used in the DYFS hearing, by the way. It simply can't be used in the criminal case. The other thing that they talk about at the end of this case, he made 2 arguments. Number 1 was, I should have got my Miranda warnings, and the court said, no, you're out. You weren't in custody. That's what DZ says. The other way he tried to attack this confession that he made, this was a shaken baby case, by the way. He shook the baby to death. Like our friend Anthony Galloway at the beginning of the semester. He tried to argue at the end that his statement was coerced. So you can have your confession thrown out if you didn't get your Miranda rights. We just talked about that at length, right? The other way that defendants get their confession thrown out and their statements inadmissible is if it's coerced. The easy one is to say the cops put a gun to my head, or they were burning me with a cigarette, or whatever. They told me they were going to kill my mother. Those are obvious involuntary confessions, right? If a guy makes a statement in that scenario, then it really doesn't have a lot of credibility. People will say things to stop the pain. And that's not the way the Constitution works in America. The 14th Amendment prevents the government from using those kind of tactics to extract a confession. Involuntary confessions are prohibited by the 14th Amendment. This guy said, you know what? One of the DYFS workers suggested, go ahead, tell me what she did, or he did. Louder.
Suggested that he or his wife would not be able to
He claimed that
they said
that one or more of the workers told him that he wouldn't get his kids back, or the kids would be taken away unless he talked. And as you examine that, the more likely scenario is, because this is where the court went in their analysis, the The more likely scenario was, if you cooperate and are honest with us and tell us what happened, you're more likely to get your kids back. If you BS us and don't tell us what happened, you're not going to get your kids back. People who are cooperative and remorseful are more likely to do better in getting their kids back. And he argued that that was coercive, that made me feel I had to say something or I wouldn't see my kids. And the court said, interesting, we understand what you're saying, but no. We do not believe that that's coercive. It's just a simple fact that they were communicating to him, and it wasn't used as a club to get him to make a statement. In fact, they start their analysis by saying, the court does, we begin with the general observation that by acknowledging their abusive behaviors, parents can begin to understand and reform those behaviors, and that acknowledgement is an important step in the rehabilitation of the family. So the court starts out by saying, listen, we all get it. We understand that if the guy's cooperative, that he's more likely to get his kids back. That's an important step in the rehabilitation of the family. And if you can rehabilitate the family, then the guy might get his kids back. And then they go on to conclude that this wasn't coercive enough, though. He had a lot of options. He didn't have to talk to them. Essentially, Dyfus and the workers didn't use the fact that separation from his children, they didn't use the potential for separation from his children as a club to coerce him into talking. And they really did. If you look at it, they said, well, if you don't tell us, we're going to take your kids. And you ain't getting them back. Got it? You're never going to see your kids again, dude. Do you understand me? Never. Well, that might be coercive. But the way Dyfus presented it wasn't coercive. And the court ruled accordingly, and his conviction was affirmed. Go ahead.
This is a little off topic, but are there laws against how long you have to deal with this child? Because I've seen Lifetime movies before where they keep on interviewing the child to see what happened, and then eventually the child gives in because they feel like they're never going to stop interviewing me unless I say what they want.
The child suspect?
Yeah.
Yeah.
I think it was like the case where the mom, like a mom was saying that in the middle of the night someone broke in, but all the evidence pointed to the brother, that the younger sister was killed or something. So they kept on interviewing him until he finally gave in, but then later on it turned out that he wasn't, but he confessed because they kept on interviewing him for so long.
Yes. Here's the way the law works. There's two things going on when you interrogate somebody. Whether they're a child, person accused of delinquency, or whether they're an adult. Two things. First, was the person advised of their Fifth and Sixth Amendment rights? I just talked about that at length. That's got to happen if it's a custodial interrogation. If it doesn't happen, then the statements are suppressed and any of the fruit from the statements suppressed. The other scenario is whether the statement was coerced. We looked at that with PZ also. He made both arguments, both traditional arguments. So how do we evaluate whether something's coerced? Well, we look at all the factors. What the cops said, were they brandishing their authority, did they put a gun on the table, did they make direct threats, how long were they interviewing him, did they lie, did they use trickery, which are permissible. But, yelling's not bad. Yelling's okay in an interrogation. It's not always an effective tool, but in the right interview at the right time, it may be okay to yell. So each of these things in and of themselves do not result in coercion. Like this guy was arguing, you're going to take my kids away. It all depends. How long someone's interview is a factor. A tough guy like me, interview me for 12 or 14 hours. I'll be tired, but I might not confess. I'm not going to confess. I'm a hardy soul. I'm not going to confess to something I didn't do. 5 days later, maybe I'll confess. I don't know. So it depends upon the kid, the person, the length of the interrogation. But mostly, during the interrogation, you brought me pizza, you let me watch the Knicks game. Things were quite comfortable. 17 hours isn't so bad. If for 17 hours I'm sweating, I can't drink, I gotta pee, you're yelling at me, you're showing me false evidence. So time alone doesn't determine whether something is coercive, but it's an important element, right? The longer someone's there, the more likely that that time is coercive. The younger the person, the more frail, the more fragile the person. So a kid, 3 hours can be coercive. You know, a tough old guy, 20 hours might not be coercive. You follow? So a child, a juvenile, a 14-year-old boy, 13-year-old boy, 4 or 5 hours can reach a level of coercion. It all depends. If they took frequent breaks, if they went to Wendy's and came back, and then they picked it up, that's one thing. If they're yelling at him the whole time, if he's 14, if he's a little slow, then the court might find this coercive. And there's plenty of research that shows that children are more likely to make false confessions than adults. Developmentally impaired people are substantially more likely to make false confessions than adults.
I think in this case they were showing false evidence, and it was like all day interviews. And they said they wouldn't let him go back to his room until like he told them what really happened, and he kept on telling them the truth. And until he actually made something up, then they let him go back and actually see his family. So they were like holding things against him in order for him to actually say what they wanted to hear.
Yeah. Now look, lying to a suspect about facts is okay. You can say, look, we got DNA, dude. I don't know how you're going to beat that. Tell me how you're going to beat the DNA. You're allowed to do that. You're not allowed to manufacture evidence. So it's a fine line. But you can't. So the things you said, individually, talking to a kid a long time, lying about evidence, telling him, we need to know the truth, and then we can go home, and I'll have my supper, those things individually do not result in a constitutional violation, which would suppress the evidence. But taken together, depending upon this kid, depending on what he's accused of, depending upon what he said, could result in that. And if they're browbeating him, they're using false evidence, so it all depends. I don't know. If that kid's, if it felt offensive to you, it probably was. It probably was. But time alone isn't the key. You follow what I'm saying? You got to look at every case differently. I've seen some tough 16-year-olds that'll, they ain't afraid of nothing. You could interview them for 7 hours. I'm more likely to fold than them, So if you're a firm resolve, just because you're a child doesn't mean that you're easily manipulated. But you have to look at everything. Are they slow? Are they limited? Are they frail? Are they there for a long time? What's the level of threat? If they say, I'm going to throw a rock at him and break your mom's window, or I'm going to shoot your mom, there's two different things, right? So you need to look at the level of threat or the coercive atmosphere. Every case is different. Any other questions? Okay, let's wrap it up for this week, and I'll see you next week.